Lisa's death. However, by mid-February 2010, as a result of detailed inquiries, discussion with experts, it was established and agreed this was not the case and no such link could be substantiated. In the light of the statements that were received, the Procurator Fiscal made some following observations. She said, in the light of statements made by the court and by the representatives of the families, that further consideration be given to holding of a fatal accident inquiry, I would like to review the following circumstances. First thing that she went on to emphasise is that there could be found no causal link between Lisa's death and the radiation overdose. So whilst negligence was admitted, there was no golden thread running between that overdose and her ultimate death. The decision to hold a fatal accident inquiry, therefore, she felt was not necessary in those circumstances. She considered public expense, and then went on to say it was not a matter of public expense, but indeed that no causation could be shown at that time. She said, there is no dispute about the accidental radiation overdose. Constructive steps have been taken since that accident by the Beatson to review and improve systems, and the cause of Lisa's death had been established and agreed. And therefore it was felt, because a review of practices had been undertaken and no legal liability was going to be shown, that a fatal accident inquiry was not going to be had. Just very briefly, just this one actually takes it out of the medical environment and shows you sometimes just how broad the range of FAIs actually could be. Here we had a 2-year-old who was standing on the window ledge of her house to say bye-bye to her nana, who had been babysitting her. She was waving bye-bye and she got tangled up in the blind cords and was hung as a consequence of this entanglement. The first notice that her parents had when they came in from work was her 6-year-old brother saying that he couldn't elicit any response from her. So the breadth here and the issue here was the parents requested an FAI. They wanted to know what had happened and what could be done in the future to stop this terrible thing happening. And so one of the witnesses that they called was the manufacturer of the blind company. And he's going, I can never imagine such a thing would happen, but I will try and rework the cord, reform the cord and the blind to try and ensure that this will never ever happen again. Now that's always a very optimistic hope, but I hope it sort of serves at least to show how broad these can actually be. And perhaps this did perform a good public service. It would never bring the small toddler back, but it may actually stop such deaths happening in the future. I'm just going to move on. I've been given the 5-minute signal. And I just want to say, in relation to this fascinating tale of causation, I hope I've managed to show that it's not enough to show that a negligence occurred, a mishap occurred. It has to be more than that. It has to actually result in a harm occurring that is legally identifiable before any of the parties can be held to account. And the purpose of a fatal accident inquiry is not to be able to investigate individuals' responsibility and culpability in those matters. Merely, if it happened at all, how can it be prevented in the future? Last but not least then, a government review took place, as I say, in 2008. They completed the review in 2009, and the government gave their response in 2011, so another quick, fast turnaround on a government inquiry there. And what they were trying to do was try to take away the whole formal legal process in relation to FAIs, particularly discretionary ones. That would be the ones that would be particularly applicable in our circumstances here, to try and debunk the wearing of wigs and gowns, to try and take them out of the Sheriff Court and put them into an environment which is more user-friendly, to try and make it less intimidating, to try and make it less time-consuming, to try and make it less stressful. Because what you have here in relation to these inquiries that are held within a medical environment is an unintentional consequence of somebody's action. But the problem is, whilst this is laudable, that they are trying to make these changes, when you have legal representation of perhaps 4 or 5 or maybe more parties, it's very, very difficult to be able to make that a more informal chat, because you're having to deal with the amount of legal professionals that are there. They're all wanting their day in court, if you excuse the pun, in relation to questioning and cross-examining. And until such times that that mechanism is taken away and the mechanism is made less adversarial and the individuals feel confident to be able to say, I'm sorry this happened. I'm sorry this happened to your family. We didn't mean for this to happen. It was a consequence of various things, and provide an explanation. We are going to continue with these FAIs. And there will be small improvements made to try and take away the formality and the pain and stress for those concerned. But until we actually make it less adversarial at the first step and allow an inquiry to go through and explanations to be made which will not amount to culpability in any future legal case, I think we're going to be stuck with them for a wee while to come. Thank you very much indeed, ladies and gentlemen. Any questions? You're all speechless. That can be taken 2 ways. Yes.
Can I just ask, in terms of the new review, has there been any... Usually folks say I've got a really loud voice anyway. Has there been any consideration given to the potential impact on professionals who will perhaps be giving evidence and apologies under the more open systems in terms of their individual professional activity?
Sure.
In terms of the NMC?
I'm afraid the honest answer to that and the short answer to that is very little. Whilst they've tried to make these environments and process more user-friendly for the families, the next of kin, there's been very little in relation to how the professional is going to be treated at that time. There was 36 recommendations in all that came through, and the government actually accepted about 34 of them. And they said they would like to encourage less hostile cross-examination. But unless you change the process, I'm really not quite sure how they're going to achieve that. I think that's really what I meant, that for as long as you're going to still continue to employ legal representation, they don't know how else to behave. You know, they will go in there, they will examine, they will cross-examine, because they're trying to do the best for their individual client. And until you actually change the process, that it is more of a kind of sit down, let's try and see if we can find an explanation. So there was a sort of an acknowledgement that it would be good that a less hostile questioning took place. They didn't really set out any kind of framework as to how that was realistically going to happen. No. No. Anything else? Stunned? Are you all depressed now? Okay. Thank you very much for your time, ladies and gentlemen. Thank you.